Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start.
Begins with a non-obstante clause and prescribes a special manner of computing the period of limitation in cases governed thereby, notwithstanding anything to the contrary in the Indian Limitation Act 1908. Stop. The first condition that is necessary for the application of Section 45 is that the suit or application should be by a banking company which is being wound up. Stop. Thus, Section 45 will not apply to a banking company which is not being wound up or where the winding up is over. Stop. It thus applies to a banking company between the date of the winding up petition and the conclusion of the winding up proceedings after a winding up order has been made. Stop. Where a suit or application is made by a banking company which is being wound up, the subsection provides for exclusion of a certain period in computing the period of limitation prescribed in the Indian Limitation Act 1908. Stop. The exclusion is of the time commencing from the date of presentation of the petition for the winding up of a banking company to the date of suit or application. Stop. Thus, where a banking company which is being wound up files a suit or makes an application on or after December 30, 1953, when Section 45 came into force, the subsection directs that in such circumstances the period of limitation shall be calculated by excluding the period commencing from the date of presentation of the petition for winding up to the date of the filing of the suit or application. Stop. These words, in my opinion, are categorical and lay down what period shall be excluded when a suit or application is filed by a banking company. Stop. Which is being wound up. Stop. I cannot agree with the High Court that in applying Section 45 the court has to consider whether the relief claimed in the suit or application by a banking company which is being wound up had become barred by limitation before December 30, 1953, when Section 45 came into force. Stop. The condition necessary for the application of Section 45 is that the suit or application should be filed by a banking company which is being wound up. Stop. Once it is clear that the suit or application is filed by a banking company which is being wound up, the court must exclude the period of limitation from the date of presentation of the petition for winding up to the date of the filing of the suit or application. Stop. In what manner the exclusion can be made will be considered later. Stop. But these words leave no scope to the court to consider whether the suit or application, if filed before December 30, 1953, would be barred by limitation or not. Stop. They imperatively lay down that where an application or suit is filed by a banking company which is being wound up on or after December 30, 1953, when Section 45 came into force, the court must exclude the period commencing from the date of presentation of the petition for winding up to the date of the suit or application in computing the period of limitation. Stop. Further, by virtue of subsection 3, Section 1 applies not only to those banking companies which were being wound up on applications presented stop.